about information security and privacy when it comes to the right to privacy and it comes to how information and personal data is kept and stored and how it's collected. I've decided to talk about the United States and Spain, primarily because they have vastly different laws between the two. The United States does not have a blanket law when it comes to personal data and how it's stored. Rather, they cover certain sectors, like the financial sector, like the healthcare sector. Technology is forever evolving, and governments must do whatever they can to protect the rights and protections and information of their citizens. Information security is the aspect of information technology that handles a government's ability or an organization's ability to determine what data is going to be stored and shared with third parties. Information privacy refers to personal information and data stored on computers and cloud services. Like I said, the United States does not have a blanket law when it comes to personal data and how it's stored. Rather, federal statutes primarily are aimed at specific sectors, like, again, the financial sector, the healthcare sector, and consumer rights. Data protection laws vary state by state depending on their own constitution. So again, in the United States, there is no real definition of personal data. Rather, their determination of the right to privacy is defined as common law rights that have been incorporated into state constitutions in many states and into the laws at both the state and federal level. 3 different laws that do protect citizens' information in the United States would be the U.S. Privacy Act, which establishes a code of fair practices that protects personal records. You have the Gramm-Leach Act, which covers the financial industry. Financial services, they must be explained to the consumers. So for a bank example, they have to share their practices with customers, and they must use the safeguard rule, which means that they tell the customers about the information collected, how it's stored, and who they plan on sharing it with. Then we have the HIPAA law. The HIPAA law protects all of our healthcare records, paper copy and electronic copy, and this has a 2-part rule. The privacy rule talks about how data is collected and how it's disclosed, and then the security piece sets up security standards for protecting the information in electronic form. The biggest thing with the United States is that it fails to identify what personal data is, and this is a huge problem because citizens don't have that guarantee that their information is actually going to be protected. Looking at Spain being part of the EU, which consists of 27 members, about 513 million people, 200 million people more than the United States. They have the toughest data protection laws in the world. They define human rights as the right to the protection of personal data and the right to get access to justice. In Europe and in Spain, obviously, it is believed that data is an asset that must be protected. This is why they established the GDPR, which is the General Data Protection Regulation. This ensures that users know, understand, and consent to data collected. Any information relating to an identifiable or unidentifiable person, directly or indirectly, by factors like their name, their ID number, online sites they visited, and other major factors. These are all what Spain has identified as personal data, and it's got to be protected and it's got to stay protected. In Spain, companies must explain why they're collecting data, and they must be very transparent. This law really boosts the rights of individuals. Again, in Spain, data is an asset and it's got to be protected. Some of the key principles of the GDPR is that personal data can only be processed fairly and for specific purposes. And this law actually defines personal data as things like your name, your address, and your last IP address. But then they even take it a step further and define sensitive personal data as things like your genetic data, religious views, and your sexual orientation. And they separate the responsibilities between the controllers and the processors. The controllers are the people requesting information, and the processors are actually the ones who are processing it. Another law in Spain that protects their citizens is the Spanish Data Protection Act, which they refer to as LOPD. This restricts the use, sharing, and storing and collecting of personal data. It's got to be very limited. Another law is going to be their Article 96, which covers telecommunications. This is a big thing that we can learn in the US because we've all been that person where we receive phone calls and we don't know what company they are and who they're calling from, or like a marketing phone call. Well, in Spain, they must clearly identify themselves immediately, and they have to immediately identify the company that they're working for. If they don't, they're in violation. It must also be a human. It cannot be a robot. Any pre-recorded or robot calls have to be given prior consent prior to. And again, in Spain, companies can only process data when prior freely given, specific, informed, and unambiguous consent is given under contractual necessities, compliance with legal operations, or only when relevant for business purposes. I think the biggest difference between the two countries is that Spain has taken it to a whole nother level with completely protecting personal data by giving a definition, by defining sensitive personal data. The United States has yet to do that. Rather, they leave it upon realtors and big retail companies to have their own policy on how data is stored and how it's protected. And if there is a breach, then they have to tell the US government, and then there could be a fine. This, I believe, is the biggest difference between the two, because in Europe, data can only be collected for a certain period of time, and it's very limited scope. And this is why I believe people living in Spain and Europe are more protected than those living in the United States, because again, the United States only covers specific sectors like the financial sector, like the healthcare sector, and they don't define what personal data is, yet alone what sensitive personal data is. So again, there's no transparency. It's all state by state. Even the definition of privacy, it varies state by state, where in Europe, it's all 27 members. They all have the same law. They all have the same definition of the right to privacy. With billions of consumer data bytes being spurred through cameras and phones and smartphones and social media, it's extremely important that we keep the information of our citizens protected at all times. So just to wrap up again, I was talking about information security and privacy, and I truly believe that the United States can learn a few things from Spain when it comes to that. Because again, Spain has the toughest laws in the world. Even their rights, their human rights include the right to privacy in his or her house. And the United States, we fall behind. We fall behind, and I believe this comes after the attacks of 9/11, where we feel more vulnerable, so we monitor communications more. But to wrap up, I believe that the United States can learn a thing or two from Europe in protecting their citizens and identifying what personal data is and identifying what sensitive data is. Thank you so much, and I hope you enjoyed it.